You're listening to the Mind Over Murder podcast.
My name is Bill Thomas. I'm a writer, consulting producer, and now podcaster. I am now trying to use my experience as the brother of a murder victim to help other victims of violent crime. I'm working on a book on the unsolved Colonial Parkway murders, and I'm the co-administrator of the Colonial Parkway Murders Facebook group, together with Kristin Dilley.
My name is Kristin Dilley. I'm a writer, a researcher, a teacher, and a victims advocate, as well as the social media manager and co-administrator for the Colonial Parkway Murders Facebook page with my partner in crime, Bill Thomas. Welcome to Mind Over Murder. I'm Kristin Dilley.
And I'm Bill Thomas.
And we're joined today by podcaster and former state and federal prosecutor, Francey Hakes, joining us to talk all about everything legal. Francey, thank you for joining us today.
Oh, sure. Hi, Bill and Kristin. Thanks for having me back.
Oh, we're loving this. For the record, the two women have somehow coordinated their outfits. They have beautiful maroon tops on. I am completely out of step, but I'll try to be well behaved.
It's typical. The ladies are ladying up here, and Bill, you're not. So it's okay.
No, but the two of you look like total glamour pusses, and you match.
We kind of match just a little bit, yeah. Great minds. Great minds.
Obviously.
Francey, before we jump back in, go ahead and remind our listeners about your professional credentials.
I was a state and federal prosecutor for just about 16 years. I worked in a couple of different district attorney's offices here in my home state of Georgia, and then I became a federal prosecutor, also known as an assistant U.S. attorney here in Atlanta in what's called the Northern District of Georgia. And for the last few years of my career at the Department of Justice, I went up to Washington on a special assignment trying to wrangle a solution to child exploitation in the country, working directly for Attorney General Eric Holder and doing a lot of liaising and testifying on Capitol Hill and traveling all over the world and trying to gather all the experts to figure out what the problem is and how to solve the problem. Since then, I have joined a Hollywood production company, weirdly, and we produce audio content for Audible and other podcasts. We produce TV non-scripted things like Indivisible and America's Most Wanted, the most recent reboot of that. And we're also working on scripted content and films. So all related to crime and fortunately in my area of expertise.
The last time we had you on, we were talking about your Audible original series, Midwest Monster, and we hope that is continuing to do very well for you on Audible.
Thank you. My most recent release was Breaking Justice, the Cain Velasquez story, and I was also EP and writer on that one. And that's an ongoing case. It's the first time we've delved into, or Audible with us has delved into an ongoing case. And it's really interesting because it's also in my wheelhouse. It's all about a man named Cain Velasquez, who is a former heavyweight, a world champion. He was arrested in February of 2022 for shooting into a car full of people and trying to kill someone. It turned out that the someone he was allegedly trying to kill was a man who had just a few days earlier been accused of molesting Cain's 4-year-old son.
Wow.
And the child molester was given a bond almost immediately within a day or two. And Velasquez was for months and months. And so our project went through the kind of California justice system as these two cases were winding their way through very slowly. We really took a deep dive into the cases, what was happening. We talked to Cain, his wife, lots of MA people and specialists and things like brain injury and impulse control, profiling. So it's that one was released in December, and we're really proud of it and hoping to do a season 2 as those cases continue.
Wow. And can you give me the title again, please?
Sure. It's Breaking Justice, the
Breaking
Cain
Justice.
Velasquez story.
And you're continuing to do Best Case, Worst Case, your podcast.
That's right.
And
My podcast with my co-host, also partner in crime, so to speak, former profiler Jim Clemente.
one of our favorite people as well.
Jim's amazing.
So you
Don't tell him I said that.
Oh, okay. Jim, we're going to take that part out. So you've got a lot of balls in the air and a lot of great projects going on.
A lot going on. It's exciting to be working in the entertainment business. It's definitely not something I ever intended to do, but it fell in my lap because of Jim. And I'm really grateful. It's been a real transition and a very different kind of third career for me, if you will.
In the last 2 minutes, there's probably a dozen things we'd like to talk to you about.
Anything you want, I'm here.
We're going to go ahead and start with the fact that we do need your legal expertise to weigh in on a case that is happening here in Virginia. And our listeners, I'm sure, are aware of it because we have mentioned it a time or two here on the pod. And that is this unprecedented situation of a 6-year-old school shooter. So we wanted you to weigh in on some of the legal questions that are probably going to come up as this case kind of moves forward. I guess really the first one for me is, can a child as young as 6 be charged for committing a crime of this magnitude?
It's interesting, Kristin, way back in the day, like long before any of us were born, kids could be prosecuted just like adults. And then in this country, we decided that that did not suit modern sensibilities. The modern juvenile justice system was created in this country. Every state has a slightly different take on juvenile justice, but it's a whole separate system. And what's really interesting about juvenile justice as compared to adult justice, the main purpose of adult justice is deterrence, incapacitation, and punishment. Those are the 3 chief reasons to have criminal justice, to prosecute people and put them in jail. But in the juvenile justice system, we don't look at it that way because we think of children as being redeemable, which is not something that they used to focus on, but now we do. And so the point of juvenile justice is that redemption, is that rehabilitation. And that's why juvenile records are sealed. That's why you don't have to even say if you have one, other than in certain limited circumstances. We recognize that kids are different. Their brains don't form the judgment centers for a long time in life. And so we recognize that children just really don't have the capacity to understand right from wrong in the way adults do. And so we treat them differently. But every state is slightly different. It seems every time there is a high-profile, horrible crime, there are certain states, usually the states where these crimes happen, that lower the age of potential culpability for children. I'm sure y'all and your listeners will remember there was a terrible crime, at least 20 years ago now. It could be 30, I'm so old, that took place in England. And there were 2 young boys who took a 2-year-old child from a mall. And the boys were something like 8 and 10.
I remember this case.
And they took a boy from a London mall and they murdered him. They assaulted him. That's all I'm going to say about that. They assaulted him and they murdered him. Just a case. And those 2 were not prosecuted as adults. They were prosecuted in the courts over there in their juvenile justice system. And one of them at least has been in and out of the adult justice system, child pornography, all sorts of terrible crimes that he's been committing. But every time he comes out, he's allowed to change his name, and no one's allowed to know what his new name is or where he lives, in spite of the fact that he is a murderer. He committed a murder, and he keeps committing these other offenses. So that crime happens. And when that crime happens, juvenile justice around the world has this kind of fit where people say, oh my God, these boys are, I think it was something like 8 and 10. They're like 8 and 10. Our current age generally in most of the states is around 12, 13, 14 for kids to be prosecuted potentially as adults. And so a lot of states lowered their age. And there are some states in this country that allow children to be prosecuted as adults as young as 10 years old. Now, generally speaking, in all those states, when someone's below the age of about 12, there still has to be an adjudication by a juvenile judge who the district attorney has to approach and file a motion and say, we think that this 11-year-old who committed whatever the heinous crime is, it's so heinous that they merit prosecution as an adult. And then there's a hearing and the judge decides, and then there's all sorts of appeals about that issue. I've prosecuted kids as young as 11 and 12 in a particularly horrific case of gang rape. There were at least 15 men and boys who sexually assaulted over a period of 10 hours a young mentally disabled girl in an apartment complex. She was 13 at the time, but had a mental age of about 8. And they held her captive, and it was horrific. And the youngest kids that we found were 11 and 12. And there were also 13 and up all the way to 29. The 11 and 12-year-olds we prosecuted as juveniles, but the 13 and up we prosecuted as adults. That was where we cut it off because we just thought the 11 and 12-year-old were just a little too young. But yeah, every state is different, and kids as young as 10 can be prosecuted in this country as an adult. The important thing to note, too, for your listeners, though, is that if someone that young, if someone below about 17 gets convicted of an adult offense, they don't go serve it in an adult prison. They serve it in juvenile prison, their sentence, until they turn, depending on the state, 17, 18, some of them are 21, and then they go to an adult system to finish their sentences.
Effectively, Francey, they graduate from a juvenile detention facility to an adult traditional jail to serve out the balance of their sentence.
That's right. If they're prosecuted as an adult, yes, absolutely.
What does that feel like for you as a prosecutor to be looking at this horrific case that you're describing, and then you have to parse, okay, the 10 and 11-year-old offenders are going to be tried as juveniles, and then the 13 and ups are going to be charged as adults. What's it feel like?
One of the top, probably 3 worst cases I ever prosecuted. It was on video. There was a lot of the sexual assault took place on video. And so that was just horrible. Lives in your mind forever. You don't forget it. But on the other hand, the stupidity that had someone film all of that was some of what helped us tremendously in finding these offenders and bringing them to justice. It's hard when you see something like that and knowing the child that she was. While she was 13 years old physically, her mind was an 8-year-old. So knowing that, it was actually hard to agree to prosecute any of the kids as juveniles because it was such an absolutely savage crime. They locked her in a closet. There's no question, but even the youngest boys knew it was wrong, right? They understood it, but they were being egged on by their older cousins and friends. And so there was some level of less culpability, we felt like. But Bill, it was really hard. And neither of those 2 younger boys went to adult prison. Obviously, they served in the juvenile system, but some of the older ones did and would have then transferred into the adult system, which you don't like to think about kids becoming adults in custody. And then that's what they know in their life. And what is their chance for rehabilitation? But I'm an old prosecutor's prosecutor. And so to me, there are some crimes and some defendants that are so heinous and irredeemable that you just have to keep them away from the public. They're just so dangerous that my goal as a prosecutor was that incapacitation. That's one of the rules of justice. Get them out of the public because you cannot trust them not to reoffend. So that was always my push as a prosecutor, was putting people in jail for as long as I thought was necessary, that a judge agreed with, that I thought was necessary to protect the public. Because to me, that's what being a prosecutor is. The goal is protecting the public. I want to get on my soapbox for just a second. Yeah. I know justice reform is a popular topic, and I agree with reform, generally speaking. We should always be looking at what we're doing. We should always be looking at whether what we're doing makes sense. But the current crop of prosecutors out in the world, especially those in some of these bigger cities, including my own beloved Atlanta, don't seem focused on victims and the public. They seem much more focused on defendants, the offenders of the crime, and what's best for them. And I don't care what's best for them. I want the public to be protected from them. And there are lots of times when a very long sentence is the only thing that's appropriate to protect the public from someone who is dangerous and has shown that they will not obey the law and will prey on vulnerable people like that little girl. Yeah, I agree with reform, but not at the cost of public safety.
When you hear about a child so young, I would also group like a 7-year-old and 8-year-old in this category too. When you hear about a child this young committing such a serious crime, as a prosecutor, where does your mind go first? What question do you ask yourself first?
Yeah, that's a great question, Kristin. And I think that you probably expect me to say my mind goes first to wondering whether they were abused. That is not where my mind goes first, because I know you guys know this, but I know the statistics, and that kids who are abused are no more likely to become offenders than the general population. It's just that the abuse excuse is constantly being used in court to generate sympathy, but it's rarely ever provable or proven or true. But where my mind goes first when you've got a young child committing a terrible offense is, what's the parental supervision like in the home? And you do worry that the child, what are they learning? What are the lessons that they're getting at home? Are they being bullied? Because oftentimes kids who are bullying, I saw this terrible video making its way around the internet where an adult man ended up, after this child, 10-year-old kid kept hitting him, the man eventually grabbed the child by the throat and threw him down on the ground. And the kid was calling women a whore. It was a crazy incident. It was a crazy incident. I couldn't help but wonder what this 10-year-old is experiencing at home that has caused him to think that behavior is okay, that he can behave that way. So does he watch someone else behave that way, or does he get away with behaving that way at home? Or is he getting bullied at home and that's a lesson that he is learning? And so he goes to school and bullies others. So I do wonder about home life when I see a very young child doing criminal acts that they can't possibly completely understand.
And it's pretty clear in the Virginia example, not all of this has come out yet. There apparently is a pattern here of really egregious behavior by I'm a layperson, but I'm going to say it, I'm a father, a clearly disturbed 6-year-old, bringing bullets to class in a previous incident, making incredible threats. There are now reports bubbling under from credible sources, however, that are indicating that this young boy showed the gun to other students during the course of the day. And of course, you start to, as we were talking about, there's the parental component to this, and then there's the where the heck was the school and school administrators. So far, the principal of the school has lost their job. And
she resigned.
So y'all have jumped from my case. You're talking about the Virginia case where you've got a very young boy who shot his teacher at school in Virginia.
Correct. Yeah. She may have resigned. That was one of those I maintained. She was told either resign or be fired. And now the superintendent of the Newport News school system has separated from that school system. So you've got the parents, and there's so many things to talk about there in terms of their failure for this clearly disturbed child. And then you've got the school system in this situation with just outrageous, dangerous, frightening behavior, tying into what you were saying, Francey. Is this learned behavior? Where does this stuff come from?
Yeah, that is an interesting point. Just from a legal standpoint, when you're talking about a 6 or 7-year-old kid, that kid's not going through the juvenile justice system. There's no provision for that. He's just too young. It's just not going to happen. So I worry about accountability and what is that child learning about there being maybe no consequence to what he did. I assume he's been tossed from the school. But I do worry about what you said, Bill. And I think that it is really interesting to wonder what's going on at home. I think also there's just a culture. I don't blame Hollywood and video games and all that like a lot of people do, but you do have to wonder normally. I mean, when I grew up, Kristin, you're so much younger. But when I grew up, sorry, Bill, when I grew up, there was an obvious difference between what was going on television and video games and the real world. And you had your parents talking to you about that. Everybody had family dinners and there was just no question, but that you understood it. And then I don't know what happened. Like the 90s happened. Things started changing with the Columbine high school shooting, and just suddenly this violence became cool and chic. And you wonder what that kid is learning at home. Where did he get the gun? Obviously, someone has done something potentially criminal that allowed that child to take a gun to school. You can't really fault his classmates if they saw the gun, if he was showing bullets earlier and that information wasn't disclosed to the school. Maybe it was. That's another problem, though, when you have child witnesses. It's the same thing in a child sexual abuse or physical abuse case. Jurors don't believe kids. They don't want to believe kids. And I don't think it's so much about jurors as it is so much about adults. And so you have to wonder, did any of those kids come and say, Timmy or whatever his name is, brought a gun to school or brought bullets to school, and they just rush it off because it's some 6 or 7-year-old saying it, and it sounds outlandish and can't possibly be true. So you wonder about all those things playing a role in creating the atmosphere that allowed this child to shoot his teacher. Ultimately, again, I'm an old-fashioned person, but ultimately, when I was a kid, I was so terrified of getting in trouble at school because if I got in trouble at school, my God, my dad would have, let's just say, whipped my ass.
Yeah.
Can I say that on your podcast?
Yes, yes, feel free.
My dad would have definitely been very upset with me, and my punishment would have been far worse at home than it was at school. And I grew up in a Southern school where teachers, at least through was it maybe 5th grade back then, were still allowed to paddle kids, which, by the way, I completely oppose. I certainly wouldn't want anyone touching my child with a paddle. So I find it horrifying now. Back then, that's what happened if you got in trouble. I just want to note for the record, I've never been paddled at school.
That's because you knew there'd be hell to pay at home.
One of those. That's right. Because I knew there'd be hell to pay at home. You have to really wonder what he was learning. Who are his role models? Are they his parents? What are they teaching him? How did he think shooting his teacher? You can almost understand a little kid bringing a gun to school to show off and something horrible, tragically accidental happening, but bringing it in and actually shooting the teacher, it's such a horrifying crime that I don't even know what to think. But my first look as a prosecutor looking at this case is what was going on in that kid's household, for sure.
After the shooting, the family of the child did put out a statement stating 2 things, and this was about a week and a half after the shooting had happened. So the family released through a lawyer 2 things. They said, number 1, the gun was secure. They said it was up on a 6-foot shelf and it had a trigger lock. They also
that has
said
to be a lie. That can't be true.
Yeah.
The shelf, maybe. What kid, especially a boy, I mean, I hate to separate boys and girls because I was a climber as a kid, especially a boy who tend to be like Spider-Man when they're that age. I was just watching a friend's video the other day, and one of his children is in a basement area and is up on this windowsill where there is no way he should be able to get up on the windowsill. Like he had to crawl up the wall like Spider-Man, because that's what little boys do. They try to find out how to get to places they shouldn't be. So 6-foot shelf would deter no child. Trigger lock absolutely should.
The family also stated in their statement through their lawyer, they said that their son is acutely disabled. That's their words. And they said that it was the first time all year, the day of the shooting, that he had been sent to class without a parent. He was so acutely disabled that his parents had to come to school with him. Now, my boyfriend is a special ed teacher. He has never heard of an accommodation like that. I don't think that there is any such accommodation or care plan like that I am aware of. And there's probably plenty that I'm not aware of in terms of the world of special ed. The family has basically stated, like, look, our son is severely, acutely disabled. And I assume that they are trying to state that this is something that led to this shooting.
Disabled does not mean violent. That's just, let's be honest.
Exactly.
That's
Yeah.
not the same thing.
Yeah.
And also, we can't move past this. I reject acutely disabled. I'll accept that for the moment. But the gun was secured. That's absurd on its face. A 6-year-old child was able to figure out whatever safety steps they took. Now, I did just double check before we started, Francey. Virginia does not require you to use a gun lock, and it does not require you to have a gun safe. I know some states, particularly
Georgia does not either.
There are not that many states that require the use of a gun safe or the use of a gun lock. Unfortunately, Virginia is definitely not one of them. Then secondarily, this trigger lock that was supposedly keeping this gun safe, that's also, I just reject it completely. A 6-year-old was able to bypass whatever locking mechanism they had.
I don't know what kind of trigger lock they had, but some of them have small keys. Did they keep the key in the lock? I mean,
it makes no sense whatsoever. The disabled aspect and the fact that this kid may be deeply troubled, as I said, I'll accept that for the moment. The first things they're starting off with are just completely absurd. And
if you have a deeply troubled child in your household, aren't you a lot more careful than that with a gun?
Yeah, but
you would think.
All we have to do is look at the Newtown shooter. That kid was clearly disturbed, and his mother thought giving him assault-style weapons was a good idea, which obviously ended up costing her life and a number of...
She actually was trying to get help and trying to get him committed or whatever you call it in Connecticut, and he was notified of that. And I think that's what sent him
But what
over the edge.
her decision to give him access to guns and to have powerful weapons in her home, I think you could make a very strong case that led directly to her death. And
I think it did lead to her death. I just have to say, though, that at 19, he could have bought those guns himself.
Agreed. I still think she showed horrific judgment in knowing she had 100%, a highly disturbed young man.
He was clearly mentally disturbed. And I don't know what these parents in this Virginia kid case mean by severely disabled. I don't know what they mean by that. I would certainly challenge that conclusion. Was he? What does the school say? Was he in special education? Did the parents attend class with him? Like you say, Kristin, I've never heard of that before. I suppose it's possible. That seems easily provable or disprovable.
Yeah, and they've said that under HIPAA policy, they're not releasing any further information about that at this time.
So that's not healthcare information to say whether the kids' parents come to school with them every day. That's ridiculous.
Yeah, agreed.
They're hiding. That's hiding.
You're listening to Mind Over Murder. We'll be right back after this word from our sponsors. We're back here at Mind Over Murder.
My other question would be so if, and again, we know that this 6-year-old is not going to be prosecuted for anything. In, say, the cases that you were talking about, where you have a 10-year-old defendant or an 8-year-old defendant, do medical and mental health conditions, are those taken into consideration with regard to charges that they face? Is that something that is looked at when you're trying to prosecute a child for a crime like this?
For sure. And I think when you're talking about someone who's under the age of 15, depending on what the crime is, but under the age of somewhere between 14 and 15, it does matter. It matters whether or not they have mental disability, because there's no point in prosecuting someone who doesn't understand that what they've done is wrong. And there are plenty of people who don't understand what they did was wrong. The question is, what is the degree of that? To what degree do they not really understand it? And to what degree might juvenile justice intervention serve the public interest, but mostly serve that child? Now, again, a 6-year-old is not going through juvenile justice, but one hopes that Child Protective Services are going to monitor him and that family quite closely until that child reaches the age of majority, which is probably 17, but maybe 18 in Virginia. But they should be following that family. There should be what's called safety plans, because something badly wrong has happened here. And the parents, even setting aside for a minute any criminal liability and any civil liability, let's just put advisory authority. Child Protective Services has the ability to insist that this family undergo certain steps in order to maintain custody of that child. The Child Protective Services at DFACS, or whatever y'all call it in Virginia, Department of Family and Children Services, Child and Family Services, whatever it is there, they should be heavily involved in this case already, if they weren't already, because maybe the child had such issues that they were already involved. But even if they weren't, they should be now. And so that ought to be a bit of a stopgap measure to ensure that child is getting the care, appropriate care, that he obviously needs in his life until he reaches the age of majority. As we've seen so tragically around this country, for example, I don't know if you ever saw the Netflix documentary, The Trials of Gabriel Fernandez. I don't know what any Netflix documentary could ever make you more angry, but a hideous, true documentary about a little boy who was supposedly being protected by Child Protective Services and was just constantly being abused by his mother and her boyfriend, and was eventually murdered by the boyfriend. You hope that Child Protective Services does their job and ensures that this child is safe, and that the family is safe, and that the public is safe from any further actions that this child might engage in. But that's really the only answer right now, I think, for public safety. Child Protective Services, and are they watching? Have they forced the family to sign and engage in what's called a safety plan? There's usually multiple points that the family has to agree to. This kind of school, this kind of supervision, this kind of after school care, this kind of education. Hopefully that's going on right now, but that is definitely something that's confidential and we may not know about.
Would it be possible to take this child away from these parents?
Yes, 100%. Yes. The very action of the child being allowed access whether it was negligently, accidentally, or on purpose. Those are really the three choices. However this child got this gun, it is the responsibility of the adults in the house. And so that was a dangerous situation to that child. And because of that, the Department of Family and Children's Services, Child Protective Services could file a petition with the court to have that child removed from the home. The minute that shooting happened, if I'm CPS, that's what I'm doing, because I want to understand what happened and get that child out of the home and into somewhere where he's protected while I go out to that home, because they have the right to do that. Go out to the home, inspect the home, search the home, see if there's anything else there that could hurt that child or anyone else. Yes, Bill, they could definitely take the child out of the parent's custody.
Almost immediately after the shooting happened and newspaper coverage started and every other type of coverage started, one of the first phrases that started showing up was, "We do not know yet if the parents will be charged." We saw in the case of the Oxford, Michigan school shooter, Ethan Crumley, that his parents were charged with involuntary manslaughter because they gave him the gun that he used to commit the murders in his school. Can you outline what are the circumstances under which a parent can be charged with a crime that their kid committed?
This is always tricky. In the case of the Michigan school shooter, there was a lot of really clear evidence that the parents enabled what happened. And generally in the law, when someone dies and that it's not natural causes, when there's a death, someone's responsible for it. The question is, are they criminally responsible? Are they civilly responsible? And what is the level of that responsibility? Is it just they contributed to it? And in civil law, there's a concept called contributory negligence. Who contributed to that person's death, but did they also contribute to their own? Did they run out into traffic, but then you were also speeding when you hit them? So that's there's like almost a 50-50 concept where you're responsible, but so is the person who's injured or dead. Criminal law doesn't really recognize that, but involuntary manslaughter is a different concept. That one is used in cases like sometimes drunk driving, but sometimes there's a death. So someone has died and someone is responsible for it. Did they do? How much are they responsible? And is it under a criminal negligence standard, which is a civil criminal hybrid? That is, you were supposed to do something, you didn't do it, and someone died, and therefore you can be charged with involuntary manslaughter. The issue, though, is that every prosecutor is concerned about proof. Can they prove it? Because no one intended, except maybe the 6-year-old, no one intended the teacher to be shot or hurt or die, but she nonetheless was. And that child had no legal, lawful right to a gun or to shoot her. So is someone criminally responsible? And I'm sure that what the DA is doing right now is exactly looking at where was that gun housed? What is this supposed trigger lock? And what other evidence might there be of the child getting places he shouldn't, getting the gun when he shouldn't? Has any neighbor or any witness or any other family member ever seen the child with that gun? Where is the gun normally kept? All these things are being investigated now, where the DA will eventually decide whether that sort of criminal negligence or involuntary manslaughter charge, which means someone's dead, you did something that caused it, even though you didn't intend to, and so you're charged. It's pretty tricky. The criminal negligence statutes in most of this country generally involve child abuse and generally involve charging a parent, especially a non-directly offending parent. So say one parent beats the child and the child is I had a case like this once. One parent did something horrifically bad to the child, and the child dies and is revived several times and eventually is taken to the hospital after receiving some incredibly serious and permanent injuries. The mother did not call the paramedics. Did not call 911. The mother didn't call the police. She was also charged for failing to get that child medical treatment.
Right.
So in the law in this country, generally, while there are some Good Samaritan laws, generally speaking, you don't owe a duty to your fellow citizen to aid them. If you see a car accident by the side of the road, generally speaking, you are not obligated under the law in this country to stop and help, to stop and render aid. But if you are a parent or a person responsible, a guardian, a child is in your custody, you are responsible for seeking help if that child needs it because they're helpless. So Under that theory, that's a criminal negligence theory. You knew something was wrong and you didn't get them help. That doesn't really apply here. Those statutes aren't really going to apply here. You instead, I think involuntary manslaughter is the closest one, and they've got to have proof that there was some standard of care that was breached here by the responsible parents.
In this case, because the teacher was just grievously injured but did not die, I imagine there's got to be some allowances made in that as well.
There's no manslaughter charge because fortunately, she did not die. It's even more attenuated because, of course, the law recognizes that if someone dies out of turn, so to speak, someone should be held responsible. She didn't die. So can the parents be held responsible for what is in effect an aggravated assault or an aggravated battery or an attempted murder? That's tougher. It's definitely tougher because all those crimes require intent. They require that the act was carried out with intent to carry it out. The parents didn't carry it out. The child carried it out. So I think it's a stickier problem for sure to prosecute the parents in that situation.
In the early going, I was very shocked to read that the statute regarding failing to secure the weapon was a misdemeanor in Virginia, and pretty much draw a straight line from, I'll use the word negligence, from the negligent act of storing the weapon improperly, because obviously a 6-year-old could figure it out, which then led to the child taking the gun to school and shooting their teacher. And as you point out, fortunately not fatally, although her injuries, as we were discussing before we went on the air, are extremely serious. She was shot through the hand. There's a question as to how usable that hand is going to be. Hopefully she'll make a recovery. It's been reported in the Washington Post. The bullet remains inside her body. She's facing some very serious medical challenges, and we're hoping for the best there. Obviously, we're not talking about, thank God, a homicide here, but we are talking about somebody who is suffering serious long-term physical and emotional damage. So there could be some liability, you're saying, on the part of the parents in terms of allowing this situation to develop.
I think if I'm the prosecutor, what I'm looking for in Virginia, what I would be looking for in Georgia and what I'm sure they have in Virginia is some kind of party to the crime statute, aiding and abetting sort of thing to the crime. It's very difficult to use conspiracy because there was no conspiracy with the child. You've got to have an agreement between the people who committed the crime, and that certainly didn't happen unless there's some shocking information out there. So really you look at the aiding and abetting statutes and to see whether a party to the crime, which means either before or after, did you aid the crime in some way? What I don't know in Virginia, because this is a really unusual situation. What I don't know in Virginia is, can you aid and abet someone that's not chargeable? That I just don't know.
Yeah.
Which is an interesting legal question that I guarantee you the prosecutors are trying to figure out right now, whether you can aid and abet in a crime when the principal actor, the one who committed it, and you can't reach them. So I think it's an interesting case. It's obviously terribly tragic for the teacher. Certainly hope she recovers. It's very difficult for the child now because hopefully there'll be CPS's thumb will be on that family for quite some time. But I'm sure the DA is looking very seriously at whether there are any criminal charges. Like you said, Bill, there's certainly going to be some ancillary charges about the gun, maybe even some criminal negligence. There are lots of statutes around the country about allowing your child to be delinquent and allowing your child to commit crimes, which is a lack of a supervision. They're almost never felonies. And this is a very serious matter. So I wonder whether the DA's office will be able to come up with a felony. They know Virginia law better than I do, so they may know very well what statute they're going for at this point.
Francey, do you feel like there could be liability on the part of the school system? It appears, based on the reporting, that there were repeated red flags regarding this child and that there were earlier incidents reported to the administration of the school. Now, we know that the principal of the school has resigned, and it was just reported a couple of days ago that the superintendent of the Newport News, Virginia school system has also stepped down. And this is directly as a result of this incident. There's no question about that. They haven't necessarily been fired, but they have chosen to step away from their roles. it feels like the school system could be liable if they knew about the fact that there had been earlier incidents. Apparently, it was reported up the chain of command that day that the child had a gun, and not all of the appropriate steps were taken because obviously a 6-year-old isn't that smart. The kid had the gun at the school, and they didn't properly search those places where the kid may have been hiding the gun, including on his person. I feel like the school system could be liable here as well.
Something similar happened in the Michigan case where there was a report the child had a gun and nobody even looked in his bag. It's just shocking. You can't criminally prosecute a school. You could certainly criminally prosecute individuals in the school. But again, crimes of omission, that is, you knew about something and didn't do anything about it, are generally rare. There aren't very many crimes like that, other than, like I was saying, in the case of child abuse. So I think generally speaking, when it comes to the liability of the school, it seems to me there's no question that there's civil liability there, that they knew about a dangerous condition and they did nothing. That is classic negligence. They knew there was a dangerous condition. They failed to act to ameliorate that condition, and therefore they're liable for the event that happened. I think civil liability seems fairly clear here, assuming all that you've said is right as far as the school being given notice about different things and then failing to take adequate steps. I would certainly not be surprised to see a lawsuit filed in this, and I imagine that the school system or the county or whoever it is will be very motivated to settle a case like this because liability is pretty cut and dried, I think.
Yeah, a lawsuit was announced earlier in the week. And so it'll be interesting to see how ultimately they decide to proceed with that. We talked earlier, you'd mentioned Columbine, for example, and that's, of course, one of the earliest school shootings that I remember. We just keep seeing this happen over and over again, this spate of gun violence in school. Having lived and worked in the criminal justice system for a while now, what would you say some takeaways are for schools and school administrators and teachers to how they respond to threats of violence? Like when you hear a kid has a gun or you suspect a kid has a gun, what is the new standard for how we should be reacting to that?
We can't ignore it. These sort of things just cannot be ignored, and it's got to be an all hands on deck. When there is a report or a suspicion of there being a child with a weapon, the school has to act immediately to protect not just the employees, but of course the other children, because that is their chief obligation, is to educate, but also to protect the children in their care, because they're basically in loco parentis or acting in place of the parents when the children are on campus and in school and engaging in schoolwork. And so they have an absolute obligation. People don't like to talk about armed guards and metal detectors because they say they don't want our schools to become like airports or prisons. I keep saying to myself, why not if it's going to save kids' lives when all they have to do is walk through a metal detector? It's not perfection, right? There's no perfect system. Just look at TSA every year. It gathers all kinds of things that make it through TSA. Someone forgets they have something in their bag and the TSA misses it. So there's no perfect system because we're all humans. But we're not doing enough. I think it's clear. Every time there is a school shooting, Uvalde was a little bit different because that guy came from the outside, and it looks like there was a series of failures, including on the part of law enforcement for cowardly failing to rescue the children and the teachers that were still alive in those classrooms at the time. Besides that, I think we just have to accept that we need to harden our schools because our schools are targets. There are all sorts of complicated factors you can talk about, mental health, and we're doing an absolute garbage job in this country of paying good attention or investing in the mental health of our youth or even our adults who are mentally ill, addicted to drugs, homelessness. We have a lot of problems in this country. What we ought to all agree on is that we need to protect all of our children better, and having schools that there is any chance a child can bring a gun in their backpack shocks me. I think today, in the year that we are in 2023, I think it is shocking that we don't all agree that our highest priority ought to be preventing weapons in schools and doing whatever it takes to do that.
I was going to say, I can't think of a better way to end than on that sentiment. There is still a lot more moving parts to this story, and I'm sure a lot more is going to come out about it in the days and weeks ahead. Francey, we want to thank you so much for giving us your insight into this particular case, and I'm hoping as more unfolds, we can touch back in with you about all of the issues that will no doubt continue.
Of course. Thanks for having me. I really appreciate it.
Thank you so much. That's going to do it for this episode of Mind Over Murder. We'll see you next time.
Mind Over Murder is a production of Absolute Zero and Another Dog Productions.
Our executive producers are Bill Thomas and Kristin Dilley.
Our logo art is by Pamela Arnois.
Our theme music is by Kevin MacLeod.
Mind Over Murder is distributed in partnership with Crawl Space Media.
You can follow us on Facebook, Twitter, or Instagram.
You can also follow our page on the Colonial Parkway Murders on Facebook.
And finally, you can follow Bill Thomas on Twitter at BillThomas56.
Thank you for listening to Mind Over Murder.